Gather the stories from every side. Ride the waves of truth on this electric tide. Commit to making the world feel small. Catch it all on Keys, we got you, y'all. At Keys' Mobile Show, we're living out loud. Resourceful and proud, attracting the crowd. Entertainment news, it's all in one place. Come join the fun, let's set the pace. From social threads to the community posts, we link up the hearts coast to coast. We build the ties in our local scene. Keys' Mobile keeps it super clean. Swipe up for the latest, scroll down for more. More than news, this is community lore. In a world that's big, we make it cozy and bright. Keys' Mobile Show flies you through the night. At Keys' Mobile Show, we're living out loud. Resourceful and proud, attracting the crowd. Entertainment news, it's all in one place. Come join the fun, let's set the pace.
Good afternoon, counsel. Can I answer questions here on the record? Versus Chontavia Stevens in indictment 22 SC 183572. Good evening, Ms. Gladden. Good evening, Mr. Stevens.
And I'm sympathetic to that. unfortunately, because he is still in a jury trial in DeKalb, which he and we probably be able to right now based on. So he's not somebody standing in and who's on the way. Obviously, we're not going to do the pre-trial hearing until both of them get here. But we can quickly deal with Mr. Burke's request to the floor. So that's all. This part of the which apparently was earlier because shopper did not off the issues. Ms. Foster, when GBC is going to be able to join. Ms. Hertzfield, can you hear me? I can. Okay. Thanks.
Daddy,
Yes.
hey, I'm still trying to reach him to tell him to sign on. I sent him the email, but, you know.
All right, so, Mr. Burke, do you need to file information? All right, also, you represent the commission that you have made best efforts to alert the court of this condition that you set forth in the circumstances, but the court takes issue with that representation. The only thing you told me at the bench the last time we were in court that you had a court date in April that you needed to be at. And you told me the reason why, and I said that we would not have court those days, that I would excuse you to that court appearance. And that is all that you said to me. And you otherwise represented to me that once you got assistance, which the court has provided in means of funding, if necessary, for experts and investigators, that you would be ready for this trial. So while I am going to ultimately grant your motion to withdraw, because I think the way it is presented, there is no way not to, it is not accurate what you put in here.
Just did you want me to respond?
If you would like to.
Foremost, I apologize if the court takes that position. That is not my intention. It's a legitimate struggle for me.
And I'm not saying it's not. What I'm taking issue with is that you seem to suggest that you had already alerted the court that the struggles you purport to be having, you had already told the court about that, and that is not true at all.
And Judge, from my standpoint, it would be true from the standpoint when we had a conference at the bench last court appearance. I told the court that I did have this trial.
You told me you had a custody case. People have custody cases all the time.
Right.
That is not the same as saying what you are now saying.
I'm not sure what the difference is, Your Honor, but
Well, to say I am having a mental condition that makes me unfit to represent anybody is not the same as, hey, I'm going through a custody dispute. And I don't mean to be blasted your business, but you're the one who's making that required.
That was the difficulty in communicating the last time. It's not something that I want to blast. I don't want my family on the media and all of this stuff, but I don't have much of a choice. I don't.
And I'm
So I'm trying
sympathetic
my
to
best,
that.
and I'm sorry if it's not to your mind. I apologize.
What I'm trying to do is make sure that people who are on trial for murder have the representation that they need. And if it's actually going to be an issue, which it clearly is, this should have been brought to the court's attention well before now. You were told at the beginning of December that this case was going to trial in late February or early March. So this morning, at what is supposed to be the second pretrial conference, should not be the first time that you say to the court, you know what, I'm not in a state to be able to do this. Okay? So I'm going to grant your motion to withdraw. And with regard to what that means for the state, I think it's going to have to mean that Mr. McMullen's case is severed from this, because I'm not going to wait on the other two.
We did, yeah. To be quite frank, the court, this will be, we're gonna have to retrial. I mean, I think it would be more beneficial, and in the interest of justice and judicial economy to push the trial up another month or two.
Well, let me find out from GPDC what they can do in terms of representation, because Mr. McMullen, and this is going to be his 5th set of attorneys, which nobody should have to deal with. That's not his fault. If they can get somebody in, that's one thing, but I mean, he sat unrepresented for over a year. He went through 3 different sets of attorneys in rapid succession because of, I think, issues with GPDC. He's had this attorney since July, but this attorney is not able to continue. So I don't know. I'm going to have to hear from them.
And I don't want to make light of Mr. McMullen's situation as it relates to his legal counsel, but I think it'd be relevant for the court to be made aware or be reminded that Mr. McMullen is serving a number of years in the Department of Corrections still. So waiting for his counsel, which I can promise you all members of the state would help whichever counsel is assigned navigate through the discovery as quickly as possible in order to prevent a 3rd trial, in the sense that Mr. McMullen's case, whether he's severed or not, would be a part of the 2nd trial because it's part of the count 1 of the indictment.
Yes, I know. The state is bound and determined to proceed with the RICO count. So I'm aware that that's going to be presented in each one of these cases. But, I mean, they're otherwise, aside from that, he's facing 1 charge. That's murder. That's a serious charge.
Agreed. But
And, you know, whether he is already in custody for other issues or not is not really what I meant. I meant nobody should have to go to court and face trial on a murder charge without an attorney who's prepared to try the case.
100%. I guess my point was, and I mean it's in all due respect that the state should be penalized for that as well, because we have limited resources.
I understand.
Employees. A 3rd trial would not be something that would be beneficial to anyone, but the state would definitely not be something that
I've just got to find out what our options are.
would get
Mr. Dark, can you, I know one of the issues that you said you faced when you first were appointed to represent Mr. McMullen was that you didn't have discovery. Now, you apparently didn't take any steps to get the discovery from the state, but you have the discovery now, correct?
Yes, Your Honor, I have the link, and I also have a 8 terabyte.
Okay, let me ask you this. Can you, because I do not know yet who will take over Mr. McMullen's representation, can you just get the entirety of your file and bring it to the court, and I will hold it. I will not look at it. I will hold it so that whomever is ultimately appointed, I can give that to them, and they can have the benefit of what you've done thus far.
Your Honor, yes, I can
Okay.
get the discovery, and I can try to have it.
I mean, not just I mean, everything you've worked on,
Okay.
okay? I mean, your entire file.
Okay.
All right, I appreciate that. Is that something you can do? When can you get that to us?
I'll have to look through the file to see, counsel impressions and notes and things like that.
Okay, I mean, you're welcome to put it in something sealed, but, I mean, your attorney impressions and work product and what have you might be beneficial to Mr. McMullen's next attorney. I mean, yeah, I'd hate for he or she to have to start from square 1 if you've already gotten to square 25, you know?
Okay.
Okay, does Mr. McMullen have any objection to that? No, okay. All right, so can you get that to Chambers by like Wednesday of next week?
I can do that.
All right, if you will do an order, I will grant your motion to withdraw. And Mr. McMullen, I'll do my best to get other counsel lined up as soon as possible. But, I mean, you know, because you've had attorneys in the case and then out of the case, in the case and then out of the case, that our public defender system is great. Our conflict defender system is pretty good. Our conflict after you move past the 2nd appointed attorney in a case is sometimes a challenge because of a lot of reasons, one of which is probably we don't pay them enough, but it's just challenging to get attorneys who are capable and willing to take on complicated cases. So I'll do what I can. Okay, so, any word, Ms. Rosser, from GPDC?
Judge, Mr. Price is supposed to be logging on shortly.
Okay.
He has not yet, and Ms. Rosser is on her way out.
Is what?
She's on her way out.
Okay.
To one speak.
All right. All right, so we're just waiting for them, and then after I speak with them and get what is hopefully a timetable, we'll just recess until we have the other two attorneys, and then we may or may not, depending upon what they say about timing, go forward with the pretrial conference.
Yes, exactly.
Testing 1, 2. Testing 1, 2.
Test.
The break is or not?
I mean, it is a superior court, honestly, it's not.
Yeah, we don't. Because then, because we got the thing. Okay, so let me see, let me get an email. So you're saying that I'm present. Should I have Zoom on here? Yes. That's a good question. I don't have to go. This one? Put this one.
Mr. Dark and Mr. McMullen have had some time to speak privately, and Mr. Dark, you had a potential proposal that might be a solution to our matter.
Yes, Your Honor. Our request would be that we sever Mr. McMullen from the main trial schedule and set his trial to begin for a time June or after of this year. That would allow me the opportunity to be fully present. And I don't think it would disadvantage Mr. McMullen or even the state. When I've reviewed the evidence that I've seen thus far, Your Honor, his connection is very tenuous. He is charged with the RiCO count. A lot of those things largely don't relate to Mr. McMullen at all. I think his connection stems from one main witness, and that witness would still be available. So I don't see the prejudice to the state. And also, I see significant prejudice to the defendant by either requiring me to remain or even trying to line up someone new with a short amount of time. I think a trial would still probably be starting around that same time. But I think this would allow the court to proceed with the other two defendants.
This would allow the court to proceed with the other two defendants and respect all the rights with respect to Mr. McMullen as well.
Okay, well, I do think it would be a better idea if you feel like you'll be up to it once you get past your personal matter, your custody matter in April, to allow Mr. McMullen some continuity of counsel. You've been his attorney since July, and I think you're the only attorney who's been with him for any significant amount of time. And I know that you've been working on the case and you've gotten funds for experts and been pursuing that as well. So I would certainly rather you stay on the case, even if that means that it gets moved back a few months. One thing I would inquire about is if you believe you will be ready to try the case and fully present in, let's say, June. at that point, we're talking about, you know, a 4-month delay. If we had to secure a new attorney for Mr. McMullen, we'd probably need to give him or her that much time or close to that much time to get ready anyway. I know the state has opposed severing Mr. McMullen out because it's, you know, a burden upon the state to have to try 2 cases instead of 1 when there is some at least alleged connection amongst these 3 remaining defendants, that mainly it appears being the RICO count, that is count 1. If we move the entire case to June, you would be ready for that as well, because really your client's facing the 2 charges, whether he's facing them in a sole trial or he's facing them in a trial where he's one of 3 defendants. Is that correct?
You know, I think that would be accurate.
Okay.
I would ask if it's possible that the court appoint additional counsel for Mr. McMullen in the event to continue to prepare the case.
Like to assist you for the next little while? All right, Mr. Lawimba has graciously joined us, I assume as a representative of GPDC. I had reached out because Mr. Dark is an appointed C3 attorney. Mr. Lawimba, I know you are just kind of parachuting into this matter.
So Judge, Mr. Dark, we already spoke. He's gonna, if the court is so inclined to move the case back to June, Mr. Dark is gonna rescind his withdrawal, and he's gonna represent Mr. McMullen in June.
Okay.
If Mr. Dark is asking for an assistant to help him prepare for the case, that's something I can look into.
Okay.
To make sure that he does have an assistant, but he's still lead counsel.
Okay.
He's still gonna be ready in June if the court is so inclined to move forward to grant his. I know he has some issues, some personal things going on, to grant the continuance until June. So he will be there to represent him. And in between that time, Judge, within the next week or 10 days, I'll be in contact with you and Ms. Rosser with that name, if anyone that we can get appointed to help assist him. Now, in all candor, that person that we get to assist him may be a paralegal. It may be somebody just to help do research or something. It may not be an attorney that files into the case.
Okay.
So that's also going to depend on, but I know he may need assistance with research, with kind of deciphering through the voluminous discovery. So I will try to get him those additional resources. So I don't want the court to look for another name to file into the case.
Sure.
That additional person may just be a really good paralegal that we can find and we can pay to help Mr. Dark throughout the process until June.
All right, I'm sure he'd be appreciative of whatever assistance you all are able to come up with. He's nodding in a sense, so that sounds good. If it is an attorney, great. If it's a really great paralegal, also great. So I appreciate you making sure that gets done.
Yes, Judge.
All right, so that'll be the plan. I know it's not ideal, but circumstances are sometimes beyond our control. So Mr. Lawimba, we'll wait to hear from you as to who that's going to be, and please let everybody know we appreciate the quick response. Well, he said a week to 10 days. So, all right. So thank you. So I'll excuse you, and we'll just wait to hear from you in a week to 10 days on who that's going to be. Thank you.
Great. Thank you, Judge.
All right. Okay. So state, that means we can, we'll wait until everybody gets here to figure out what the new date's going to be. Oh, we've got somebody here now. Okay. Okay. Do you know, and I know that, apparently some things happened at the DeKalb courthouse yesterday and they got delayed, so they're doing closings this morning. Is that right? Yeah. Yeah, well, yeah. Okay, so do you think that is he going to be tied up the whole day?
I would think that the jury should have gotten it by now, so they would start at 9:30.
Okay. Okay, because we're actually still waiting for the 3rd attorney as well, who represents the 3rd defendant, and I'm wondering, he's allegedly been on his way for about an hour, but I don't know where he was coming from. I think maybe Forsyth County. Oh, that's where you came from. So do we know, Mr. All right, speak of the devil, so to speak. Okay, why don't we take a quick recess? We'll get everybody back in place, and then we'll go on the record and sort out kind of how to move forward. 15 minutes.
order remain seated.
All right, so we have Mr. Katz standing in for Mr. Mondelli right now, and then we have Mr. Johnson and Mr. for a pretrial conference, and we have sort of adjusted our schedule a little bit due to some matters that have been dealt with now, but we are now looking at a June trial date instead of a March trial date. So if everybody can look at their calendars, I would propose that we start jury selection the week of June 9th. And what it had looked like jury selection was ultimately, when we talked about jury selection before, I think I at least was picturing that we might be doing some of the beginning proceedings up in the big jury assembly room, but having talked to jury services, we're not going to be able to do it that way because they have a whole lot of other jurors up there at the same time that it just, there's not the right kind of space. So what we would be doing instead is having probably 60, 55 people at a time down here in this courtroom. And if we're thinking, which the last time we talked, we were thinking 400 or so should get us enough to choose a jury from, then that's 2 weeks worth of that, I think. We can, Monday, Tuesday, Wednesday, and Thursday is when they have jurors available. And so we'd basically do, 55 Monday, 55 Tuesday, 55 Wednesday, 55 Thursday, and then we'd have to do a second week of that as well. What I'm thinking is that we could, at the same time we do the questionnaire electronically, which everybody should have gotten a copy of, and I haven't gotten any comments back about anything needing to be added or taken away, but I'll circle back on that in just a minute. Whenever we do that questionnaire, we essentially would just sit in here while they fill out the questionnaire, they hit submit, and it goes immediately by email to each of the attorneys so y'all can immediately see what the responses are. I am thinking that even though we're going to have them all back again to do the individual questioning, that we could at least hear from people that first day they're here on potential hardships, and then we don't have to make a decision right then. But we can do that then. And then by the time we have them, there may even be some that, oh, it's so clearly a hardship, we don't even have to have them back. But that's kind of what I was envisioning, unless anybody has a strong objection to handling that part of it that way.
Not mistaken.
Okay. All right. Okay. And I know we've got some motions in limine to deal with, but just in terms of the process for this first part of the jury selection, having had an opportunity to review the proposed questionnaire that would be on the electronic form, is there anything that anybody either has objection to having on there or feel at it? It largely came from what was used as, I guess, a paper questionnaire, the first YSL trial. But y'all let me know. Okay, thank you.
And good morning, Your Honor.
Good morning.
Opportunity to look at the highlights that the court had on the version that was emailed to us. Then we were going to go through it.
Sure.
By the highlights, comments.
All right. And of course, my copy is not in color, it's in black and white, so all of the highlights are gray. Because as you all know, I had some highlights that were for IT for purposes of putting the survey, uploading the survey, and then some highlights that were for us to discuss. So, oh, there we go. All right. So I think the first question was on page 7 of the survey about, would the question about, have you served in a jury trial before? And then if yes, what type of case, criminal, civil, court-martial, I don't know, or I don't remember, I don't recall. is court-martial, is that going to cover enough for everybody of, have they been involved in a military case?
Yes, Your Honor.
No, I would, or been subject to any form of discipline under UCMJ, because the military has judicial and non-judicial punishment.
Okay, so this was, we can add that question if it's not in there, but this was like, have you served as a juror before? So I think there's, later on, we maybe get to, have they served in the military at all? So let's go through it, and if we don't see that question, then let's circle back. And it's under what was the discipline under?
The Uniform Code of Military Justice. UCMJ.
Okay. All right, so everybody fine with just, we ask, have you served in a court-martial?
Yes, Your Honor.
All right. The next question that I wanted us to discuss was on page 12. What's currently Q50? That was on the original survey that was used in the first trial, but it seems like sort of after this, we ask a lot of different detail about what kind of training, what kind of experience. So it seems like this may be covering the same thing and might be superfluous. Is that one that we could do away with?
The state agrees we can do away with it.
Okay. Any objection from the defense to doing away with that question, since we ask it essentially in greater detail in further questions later?
No objection, Your
All
Honor.
right.
I do believe that the subject matter is covered in questions 51, 52, and 53.
I do too. Is that all right with everybody? All right, so we'll strike that one. Okay. All right, and question 55 is actually, have you ever served in the military or armed forces? So I guess if we wanted to ask that discipline question, that might be the place to put that? Okay, so then, have you ever been disciplined under the UCMJ would be the question. Okay, let me jot that down. And then, if so, we can ask them for details. All right, thank you. All right, I think next one is page 18. What's currently question 73. This is the way there was a question worded this way on the original questionnaire. Is this how you want it worded? Does anybody want to change that wording?
Your Honor, and to be clear, the jurors will complete this after either hearing the indictment or the summary of the
The
indictment.
summary of the indictment, yes. And we'll have to discuss how much
So
detail we want to include in the summary.
I'm not the best wordsmith, but I thought we could just ask, this case involves allegations for several individuals.
I think so too. Allegations against several individuals. Everybody okay with that wording?
Yes,
All right.
And I think in paragraph, or in the second sentence,
The alleged events,
surrounding these allegations.
strikes surrounding these arrests. And then I'm just going to say are alleged to have occurred between, is our correct date still?
No, Your Honor, I believe it'll be March 2022. I want to confirm.
And then how about the beginning date?
Yes.
All right.
I'm not clear, you're saying January is correct, and it's on March.
It sounds like January 2015 to March 2022. All right,
Oh, and I'm sorry, Your Honor, April 2022.
April 2022, okay. All right, then our next question is on page 20, what's now question 80. And I was just unclear, and I think they might be unclear as well. Where the question currently asks about how much time you spend on the internet, and then they can choose different answers. And then the next one is how much time do you spend on social media? And they choose, do we mean how much time do you spend on the internet aside from social media? And then also, do we mean, or do y'all mean, these are your questions, time on the internet that's non-work time? Because I'd imagine some people have to be on the internet all day for their job, so you would get, 5+ hours is the answer. So do we want to clarify that question some?
Yes, Your Honor. And we thought that for question 80, the concern is more of how much time you spend on social media.
That's
versus
kind of what I thought,
internet.
okay. So then do we just, if we get the, how much time do you spend on social media per day? That's really what everybody wanted to find out?
No, Your Honor, I mean, as far as the combination of questions.
Yeah.
I believe that question 80 should ask how much time do they spend on the internet side.
Okay. So then maybe I'll flip the,
And the second, I believe that both questions are necessary because what it does is it provides us an opportunity to see the delve into things that they may be into
Okay.
outside of
All right.
social media, meaning blogs or anything.
all right. So how much time do you spend on the internet today aside from time on social media? Or separate from social media? How do you want to ask it?
Well, I think the first question should be aside from work. That would give us
Okay.
how much time they're on.
Aside from work, okay.
Yes, Your Honor. And then with the second question, how much time do you spend on social media? That would allow us to then delve into what do they go and what are they on the internet
Perfect.
for outside of social media.
Okay, so question 80, how much time do you spend on the internet per day aside from work? And then the second question would be, how much time do you spend on social media per day? Does that work for everybody? All right, sounds good. All right, page 29. And I guess this is more a question for the state than the defense, because the indictment and the evidence, it sounds like, are narrowed from our last trial. So which of these questions will we still need?
Your Honor, we think we do not need question 114 and question 116.
Okay. All right, thank you. The next page, page 30, question 121. Do y'all want the word paraphernalia?
We like items. We like
Okay,
suggestions.
we're going with items. Thank you.
Your Honor, and on page 31, question 124 is duplicative of question 53.
Thank you. So let's see, where's the better place for that question? Did you say 53?
Yeah. It's worded slightly different, but 53 is, have you ever studied or received any special training or education in criminal street gangs? And 124 is, do you have any specialized training or education about street gangs?
My question 53 is, are you divorced? If you are divorced or widowed, please list your former spouse. So oops.
So I'm on page 13.
Okay. Oh, you know what? That's 63 and I just can't read or can't see. I can read, I just can't see. Okay, yes, there it is.
I think it's better at question 53 than at question 124.
Okay, so let's strike question 124. Because it's already been asked. Thank you. All right, turning to page 35. Question 142. This is just how it was worded before. What is it we're asking at that point? Are we just saying, do any of you know these three defendants or their families? In which case we would just list those three defendants and their families?
Your Honor, we believe we need to ask for all 28 only because the case did involve these other individuals, and whether or not they have although their cases might be resolved, if they have a relationship that may or may not have a bias towards the state and the.
Okay, then it wouldn't be, though, who are defendants in this case. It would just be, here's a list of the defendants from the indictment, but we're not, okay. So it would just be, do you, a close family member or a close friend, know any of the following people? And then it would be the list of everybody who was a defendant.
Yes.
Okay. All right, and then do you, a family member or a close friend, know any of the following lawyers? At that point, it seems like that's just the lawyers that are in this case, state and defense, right?
Yes, ma'am.
Okay.
And Your Honor, as to this
Maybe we can see if one of those that's on this podium might work. We seem to need to put new batteries on a lot of these mics again.
Yes, Your Honor.
Better.
As to this question, I believe that if the question is asked as far as do you, a family member or a close friend, know any of the following people, given that the family members and close friends are not would not be on the stand, we would not be able to go into that relationship to understand how the family member or close friend would know any of these individual people as far as the showing of any bias in this case. So I do believe the question should be limited to the juror itself and asking them, do they have any knowledge of these individual people?
And it almost seems to me like the only way that they would know if a family member or a friend knew of whomever this is we're asking is if they too knew about it, because otherwise they're only speaking from their own knowledge. So would that work for everybody if we just say, do you know any of the following people? 142 and 143. Just say, do you know any of the following people? And it would be first the list of the defendants, and then on 143, the list of the attorneys that are involved. Does that work? All right.
And I guess, Your Honor, to clarify a little more, I understand that this language, do you, a family member or a close friend, is probably going to be asked in other questions as far as it relates to criminal activity or violence of
Right.
A victim of a crime. I believe it would be more appropriate in those situations
Agreed.
because it may have a direct effect toward that individual rather than this situation we're just talking about hearsay knowledge that they may have from someone else.
Agreed. I think that makes sense. Thank you. All right. And then for question 145, and we'll make the same alteration. Do you know any of the following individuals? I have no idea who we're listing here. So I'm going to need a list. If y'all can get together on who we need to list, I would assume it would be all the potential witnesses and all of the victims, right? But I don't know, if it's the same as it was the last trial. So I'll need y'all to put together that list and get with each other and make sure you agree that it's covering everybody. So I'm going to write down here, attorneys will put that together and submit to the court. Let's say April 15th, tax day. Because we do have to get we have to actually, I think, upload all of the questions, which might involve actually keying them in and then getting them to jury services and then running a test on it and all of that. So why do we say April 1st? By April 1st. All right, the next page, I'm just wondering, is that the phrasing we mean? Or do we mean, do you actually know this person?
Yeah, so we thought, do you personally know?
Okay. Good with everybody to make that change? Okay. All right, and then 147, 148, and 149, do we need any of those questions in this case?
Your Honor, we think we do not need 147 or 148.
Okay.
We would ask, I thought we asked this initially, but we are asking, have you ever heard of 30 Deep or Blue Jeans Bandit? Or the Blue Jeans Bandits? And that could be one question.
30, all right, so I'm sorry, 30 Deep or who?
Blue Jeans Bandits.
Blue Jeans Bandits. So do you want the sex, money, murder?
Yes.
So do you want 30 Deep and Blue Jeans Bandits as one question or as separate questions?
That could be one question.
Okay. All right. And that was all that the court, needed clarification on. So we've gone through those. So hang on, 151. Thank you. Good call. All right, let's look again at so if we start, yes.
On the jury charges, if we could go back to number 71.
I'm sorry, 70 which? 71, okay.
Yes, I do believe on 71, we may want to add the word hearing in that, and do they have any difficulties reading, speaking, hearing, or understanding the language?
All right.
And then also, I was just going through, and I understand that I did not see a question regarding hardship, and if I understand that you may go back and reorganize these some. As far as the statutory questions, the question regarding hardship, number 16 regarding residence, number 23 regarding age, and 34 through...
Oh, you're going way too fast.
I'm sorry.
All right, 16 residents, 23.
Is age.
34
and 36 are the statutory questions. I did not see a question regarding hardship.
It's question 151.
And I was just suggesting that if those group of questions could be grouped together and placed at the front of the questionnaire, therefore I believe that would facilitate our determinations on those subjects moving forward.
Okay, so
So the kind of, almost like 1 through 15 are, well, 1 through 14 are kind of like just identifier questions, like what's your address, things like that, which is kind of what we have on our jury summons that comes back anyway. The residents, 15 and 16, about Fulton County. And honestly, like 17 and 18, oh, how many years have you been a resident? And let's look back on page 4. So have you been a resident? Are you a resident of Fulton County? Have you been for the last 6 months? That would qualify them or not. So then after that, it's how many years have you been I guess that is Fulton County resident. I'll add that in so it's more clear. 18 is other places you've lived and for how long? Does anybody want that? I mean, I'm happy to strike any number of these if y'all don't necessarily want them.
That's question 18.
Uh-huh.
I would ask that question.
Okay, I mean, it's fine. If you want it, that's fine. But if nobody really cares, there's no point asking. So that's fine. How long have you lived at your current residence? It's easy enough to fill out, but does anybody actually care?
Yeah, I think you could strike 18, 19. As long as they're a resident of Fulton County
Yeah.
at the time. It's not that it matters.
I mean, I kind of agree, but Ms. Johnson,
The only reason that I was asked that question 18 be allowed, Your Honor, is because given the subject matter that we are dealing with here, this is a subject matter that these individuals may not have experienced here in Atlanta, but may have experienced in another jurisdiction or location.
Yeah, that's fine. So how long, we've already found out how long they've been a Fulton County resident and then where else they've lived and for how long. Do we really need to, do we need 19? Anybody object to striking 19? All right. All right, so then essentially the next ones are really kind of talking about, well, do you rent or own? That's has to do with being a resident. And then it's just some more marital status things. Then we get 22, 23, and 24 are, you know, are you qualified or not? And then what was the next one? 30? Okay.
It's statutory questions on the,
So just move, you're suggesting move the statutory questions up before the, have you served on a jury trial?
Yes, Your
I
Honor.
don't have any objection to that. We can move those.
Along with the hardship question as well.
I'm going to ask the hardship question last. Because, yeah, I'm just going to ask the hardship question last. All right, so move 34 through 36 to... All right, so here's what it is. Right now, it's those age questions, residence questions, and then did you sit on the grand jury that returned the indictment, which would be a qualifier, and then it flows into, have you ever served on a grand jury? Have you ever served on a trial jury? And that is why it was before the statutory questions. So if we move it, I guess we'd move it to just below 23 before the grand jury question.
That's fine, Your Honor.
Anybody really care one way or another? Okay. All right, so I'll make that question, put that in between 23 and what's now 24. All right, so going back to question 151, which is the last question on there, and which is saying, all right, here's when we expect this trial to be. Do you have any hardships? I'm thinking if we start and have 2 weeks of these questionnaires, the week of the 9th and the week of the 16th of June, that would give us, how long do you think it's going to, when we do, y'all will have a lot of information about the jurors by the time they come back for individual questioning. So how long do we anticipate it taking to do individual questioning of 400 to 450 jurors once we've got 37 pages of information on them?
Well, Your Honor, I know in the, as Mr. Eppinger was part of the first trial in this case, Judge Glanville went through the hardship part of the questions first. And once we eliminated all of those people, then we started.
Yeah, so that, what I'm proposing is while they are here the very first time, they fill out this questionnaire, and then anybody that has a hardship or thinks they have a hardship sticks around and tells us all what that is. And then we may not, some of them, we may just say, yeah, no, that's legitimate. We're excusing you. You can show up for some other jury some other time. So some of them, so we'll have questioned them about the hardship already that very first time we see them, the same day as the questionnaires, okay? So when we come back, we'll have gotten that out of the way. So when we come back, it'll be whatever y'all might want to follow up on from any of this.
Your Honor, and thinking through the last trial, it took sometimes between 30 minutes and an hour, but we had more.
Per witness? I mean, per potential juror?
But we also had more individuals, so
Yeah.
it may not take as long.
We only have 4 people asking questions this time.
Right, so if you give each person about 20 to,
I don't anticipate, why would we need 20, 40, an hour and 20 minutes per juror when we're already going to have 37 pages, which, you know, and a lot of them has a blank to give us detail of information about them.
because depending on how many of the questions we followed up on.
Okay, let me say this. We are not going to take an hour and 20 minutes per juror. Y'all are going to have to hone your questions, and it is not going to be tell me your life story with everybody. We don't need to know their life story. We need to know, are they going to be able to be a fair and impartial juror? So I'm used to striking a jury for a murder case and doing the entirety of it in a day, having 60 jurors and going through everything and having my jury by the end of the day. I don't intend to take 5 months to strike a jury. Okay, everybody clear on that? So let's realistically think about how long it's going to take.
Well, Your Honor, given the fact that the defense goes second,
Yeah.
we have the opportunity to hear the questions that were asked before and not repeat them. So
Yeah.
We will be dependent upon the state's questions
Okay.
as far as the time frame in that matter.
Your Honor, just doing the math, it's 60 in one day.
Yeah.
It'll take 6 days,
Okay.
roughly.
So, all right, so if we do June 9th week and June 16th week as the questionnaires and the hardships, and then we have people back June 23rd week and the, beginning of the June 30th, July 1st, 2nd, maybe 3rd week, we're looking to start trial after the 4th of July. So maybe, like the evidence itself. So maybe we say on our question 151, this trial is expected to start in July, sometime after the 4th of July. After the 4th of July, which is a Friday, is expected to start after the 4th of July and last somewhere between, are we all still anticipating between 1 and 3 months? Okay. All right. So I'll make that change to question 151. Any other comments, additions, objections on this jury questionnaire?
Your Honor, on the previous questionnaire, we had asked the jurors if they had social media accounts, their handles. Would the court be inclined to ask their social media handles?
No, the court would not be inclined to ask that. Anything else?
Yes, Your Honor. I was just thinking that if we're starting the trial in, I guess, after the 4th of July, then any juror who may potentially have travel plans on the 4th of July could affect the questionnaire process itself. So I was just wondering if we may want to flesh out in question number 151 what a hardship is in this particular matter so that we can get a better indication.
Oh, yeah. I mean, it says, please describe in detail the nature of your potential hardship. And then we're also going to talk to them in person, face to face, that same day about what it is. Sure. All right, is that everything? We think we have our juror questionnaire? Yes, yes, yes? All right, sounds good. All right, one other thing I need to know, we all need to know, is the number of additional strikes that I might grant I don't know if I haven't seen any requests for additional strikes, but we do have a 3 co-defendant case. Anybody have thoughts on that?
But I'm not talking about one, but I assume that we would ask for additional strikes and very quickly.
Okay. Do y'all know how many you want? 1 apiece? And do y'all want to share them? Like 3 for the defense, or do you want to have 1 each? Or one additional each and 1 additional for the state? You get however many I want to give you. You want 3? No, it doesn't have to be equal. You want 3. I'll take that into consideration. It would be within my discretion. I am not going to be giving you 3 per defendant.
I guess, Your Honor, my question would be, with the general fact that we get 9 per defendant, are each one of us going to have 9, or do we have to share those 9?
No, you don't get 9 per defendant. You get 9. And then you're going to get a total of 12. So y'all let me know whether you want to sort out on your own. Does that mean 4 each? Or does that mean 12 pooled? Y'all let me know. You know what I mean? Are y'all going to huddle on them all and decide on something, or are you just going to, y'all will have to figure that out. And then we also need to sort out how many alternates we feel would be prudent for this case. We started with 6 last time and remarkably made it through a more than year-long trial, only losing 2. But
I would say 4.
I think so too. 4. Everybody good with 4? All right. Okay. I'm trying to think whether there's anything else we need to talk about with regard to just the kind of jury selection process. Nothing's coming to mind for me. Anybody else?
So I just, since I'm not that familiar with the case standing in.
Sure,
Right. My question is, I didn't see, and I just was able to look through questions this morning. Is there questions that relate to jurors having been familiar with the other part of the trial? Did any of them attend the trial? Did any of them watch it?
Yeah, I think that's
I didn't see where that was starting. Maybe, but I didn't see it.
some version of that is on there. Let's look back.
I just wanted to make sure.
Sure.
Your Honor, to start on, end of page 18,
Okay.
What number was it?
question 73,
73.
and going into about 77.
It goes through, yeah, 77. And then I guess it kind of, 78 and 79 are like kind of related, but don't exactly ask that. Now, it does not currently say there was a prior trial with different defendants, and I don't know that that would be appropriate to say anyway. So we're kind of asking more broadly about the case, your familiarity with the case. It's been in the media. Have you watched it?
Well, actually, I don't see a question, and maybe it's superfluous, but asking, did you actually ever attend the case? Is that how you came here?
Okay, if yes, well, we could add it as a potential source on question 74, because if you have familiarity, from what source or sources have you heard about this case? I mean, we could just make another list of it, be like court proceedings or attending court.
Well, I think to address Mr. Kathy's concern, if we had just added in question number 76, I have attended the court proceedings where asking how would you characterize your familiarity with this case. You could ask in that particular question whether or not they have actually attended the court proceedings with this case.
Yeah, that'd be great.
So I'm sorry, are you proposing add a fourth line that's I've attended court proceedings, or add a descriptor of, if they say I followed the case, describe how? Which would you prefer?
I prefer the defendant.
Just the cleaner. All right, so, 74 or 76? Maybe just, I mean, it might be a more clean on 74 than 76? Attended proceedings, attended. Does that work for everybody? Okay, thank you. All right. Now, we had a couple of motions in limine, so I'm going to move on to that if there's nothing else we can think about with regard to the jury selection process. All right, each of the defendants has filed some version of a motion in limine to exclude rap lyrics and/or rap video. There was a ruling on this broadly in the last version of this trial, which everybody at least started involved in. One thing that is different is that since what was Judge Glanville's ruling, the Baker case cited by at least Mr. Mondelli in his motion has come out. That's a case from March of 2024, and I think Judge Glanville's ruling predated that. So I do want to give that consideration because that's a new case. I've looked at the case. I've looked at other cases about videos and lyrics. If anybody, I don't think I necessarily need argument, but if anybody wants to make argument, I'm willing to listen.
Well, has the court already taken a position on it?
I've already looked at the law on it. I've looked at the motion, the response, the previous order, the case, and other law.
Well, the only thing I would say, Judge, is read that not in the Baker case. It's actually a long.
It is long.
And still, I'm not saying it is a blanket rule as to whether video shooters shouldn't come in, but certainly you still need to have a 401, 403, 404 determination, which I think comes upon the state to come in, show those videos, pre-trial, and determine whether they are innocent or not, what's the relevancy of it, whether it's more prejudicial than beneficial, and therefore have the court determine per each video should it come in.
Okay.
And I don't think there's any other way to do it other than to see video. I've only seen 2 of them. I don't know how many there are, but the 2 I've looked at don't seem to indicate anything. Certainly in the Baker case, the state, I think, needs to say on the record what is their purpose and intent and why they feel they need it in order for it to come in. Just because it's a rap video doesn't necessarily mean it does. It doesn't come in the 2 videos I saw. There's nothing about gangs. There's nothing about killing people. There's nothing about burying people, killing snitches, things that were referred to in the Baker case as far as which should or should not come in. Mm-hmm. It was just music videos. Really didn't seem that harmful to my client, although I've not seen the other 3. But certainly my concern is what juries have a tendency of having gang activity been such a big deal in the news and the trials, and almost every murder case now is considered a gang case. Does that in itself become prejudicial when the jury was to hear, oh, they're all rap videos and it automatically assumes that a rap video or rap video or a lyrics or song from a rap video doesn't necessarily be a gang case. And that's what I think needs to be looked at very closely anytime that is entered into evidence.
All right, appreciate that. Yes, sir.
We just had a brief argument with respect to the 403, 404 analysis. The videos, by my count, it's like north of 200, it's probably more. I'm still counting through. All of those videos, obviously, are not relevant to this case. My client is not a rapper. He does not appear in any videos that we've seen. He's not been mentioned in any of the videos that I've seen. None of the alleged conduct that he was purported to participate in is mentioned in these videos. And so under that analysis, it just seems like overkill. It seems like the probative value, I don't see any at all whatsoever with respect to my client. I don't know with respect to the other clients. I don't know their status if they are rappers or not. I know my client's not. But the potential for the jury to just kind of lump him in with what's rapped about, I think is very high. Additionally, Your Honor, there's an argument that, you know, lyrics are not literal. What's rapped about in a music video does mean that you did it personally.
Right.
And so I'm just really, really concerned with the probative value, to me, based on what was substantially outweighed by the prejudicial effect.
All right.
I don't see it.
Understood. So I think we're dealing with, I'll let you have your say, but I think y'all are kind of, we are potentially needing to address two different things. I read these motions as sort of, I would like a blanket exclusion of any rap videos or rap lyrics because Baker says that should never come in. That's one issue. Y'all now seem to be saying there may be particular videos or particular snippets of rap lyrics that don't meet either 401 or 403. It is incumbent upon you, if you believe that, to file a motion in limine. The deadline for filing motions in limine already passed. Lucky for y'all, we've moved the trial date. I do not, since we are going to be starting this trial from scratch, want to be litigating what should be motions in limine about the admissibility of specific evidence during the trial. We now have more than sufficient time to litigate the admissibility of everything beforehand, but the defense is in possession of all of the evidence, right, State? Yes? Okay. It is incumbent upon the defense to identify what specific evidence they think is either not relevant or so overly prejudicial that it's substantially more prejudicial than probative. I'm going to give y'all yet a third motion in limine deadline. Anything not filed by that date, I mean, I'm just not going to entertain it, okay? Y'all know what you're supposed to do. So I'll get to what that deadline is going to be in a minute. But right now, let's focus on kind of what I'm reading as more of just kind of blanket, this shouldn't come in because it is rap related.
Judge, the position I take is that I don't see this being any different than motion, any different than a motion to suppress. We have part of the court, the state wants to use those things. They come into the court, show us what videos they want to use, and the court makes a determination as to whether that's probative, whether it's relevant or not. I don't think for us that we don't have to worry going forward. I think the state does because they will use it. Just not put it in a motion to suppress.
Well, I can get some clarity from the state about what evidence they intend to use, because I do think it's going to help everybody to, much like we did later on in the trial, really know what it is that is going to be presented so that we can all be on the same page about it. I want us to do that. But it is not incumbent upon them to say, here's Exhibit A. Anybody have an issue with Exhibit A? Here's Exhibit B. Anybody have an issue with Exhibit B? They're going to say, here are Exhibits 1 through 300. This is what we're going to use. And y'all are going to look at 1 through 300 and say, motion in limine as to item number 57, 73, 82, and whatever it is y'all want, and then we'll litigate them.
The other thing I'll say, not having this court before, and I'm not trying to be argumentative, my understanding is that a motion in limine can be done at any time, even during trial. If it only becomes apparent then, okay? So if there's some sort of evidence that they discovered the day before, then maybe we're doing a mid-trial motion in limine. But if it is evidence that y'all have known for months before the trial was going to be presented, no. Okay, all right. Okay, so, I'm sorry, Mr. Johnson, did you want to say anything on kind of the more broad issue? Okay.
I understand right now, we've been given quite a bit of discovery that has a great number of different videos. As Mr. Katz pointed out, we do not know exactly how the state is going to present their case, which video they're going to prevent, which snippet they're going to emphasize. So at this point in time, all we can do is object to, on the broad scale, to the introduction of all of it. Also on the ground that a lot of these videos can be possibly construed as improper character evidence, because if none of these videos state specifically how specific things as it relates to these particular crimes, then the introduction of these videos, the backgrounds of these videos, the sounds and things that they may be doing in these videos could be construed as the jury as improper character evidence in this particular case. That's why we believe that they're highly prejudicial in this matter. And if these videos in question do not specifically speak to any kind of crimes that the state are alleging that these people have done in this indictment or any other crime, then basically there's a situation where the probative effect is very minimal, while the prejudicial effect of all these videos are very high, and possibly could confuse the jury and inflame the passions of the jury based on some of the actions and things that may have been said in some of these music videos, including holding guns, flashing certain symbols and stuff like that. And if the state is going to say that the flashing symbols and stuff is gang activity, they are able to present that evidence in other ways that may not be as inflammatory as the music videos in this case.
All right, well,
Your Honor, I'm going to be brief because I know this honorable court is well abreast in Baker and rulings related to this topic, but for clarity's sake, with the chart that the state provided to the court and defense counsel on the first page, which is what's in the redacted indictment, the only thing I would classify as.
Let me find the chart.
Yes, Your Honor.
All right, I've got it. Thank you.
So this is from the original indictment numbering, but overt act 60, which is going to be one of the overt acts, the original overt act number 60, that is just going to be audio. There's
All right, hang on.
Yes,
That is. So this is the 4-page chart.
Correct, Your Honor.
I'm looking at the right one, and we're looking at what is item 21.
Correct, Your Honor.
Overt act 60, okay.
And for number 23, 2 down, there's no gun flashing or anything like that. It has a music video.
All right, so are both item 21 and item 23 going to be music videos?
Only number 23, Your Honor.
Music videos.
Only number 23, Your Honor. And the reason I addressed that is that a number of either previously litigated or ruled on are not going to be, the state's not intending to introduce, so I wanted to make the court in defense, which this chart endeavors to do, narrow the universe of what would be classified as, a rap video that would fall under like Baker analysis. The only other one, Your Honor, that comes close is if you go to the 4th page on this chart, it's number 13 on that last page. Original overt act 95. That's a very short clip, which the court is aware of these exhibits from. But I also wanted to highlight for the court, just for note purposes, that all 3 of these, and I'll start with in order, Your Honor. So going back to number 21 on this chart, overt act 60, in the November 27th of 2023 order by the Honorable Chief Judge Glanville, page 34, number 5 is the one addressing that. And for number 23, Your Honor, which was originally overt act 78, if you go one page over to page 35, number 14 is that song. And then in relation to the very last one, overt act 95, on page 4 of our chart, the number is 13. In that order is page 36, number 18.
Okay. All right. All right. Do you have any argument with regard to the broad holding of Baker and if and whether it applies to this case?
Your Honor, just quite succinctly, and I know the court is aware of this, quite significant difference is that Baker was a malice murder trial, felony murder. It did not have street gang charges or evidence the state needed to prove to meet that, and it also didn't have racketeering or RICO charges. I think that is a quite significant factor that distinguishes the fact pattern in Baker, where that single video became a huge focus of that case, which was specifically addressing malice and felony murder, whereas in this case, there is a lot of other relevant admissible purposes, such as association, a number of things that are unique for the street gang charges and the RICO charges.
All right. Thank you.
Yes, Your Honor.
All right. So my reading of Baker and case law surrounding rap lyrics in the context of a gang or RICO case versus in the context of a case that's not a RICO case or not a gang case, I do think there are some distinctions, and I think that's significant that Baker was not that type of a case at all. I am going to deny the motions in limine to the extent they are arguing that either because it's a rap video or because it's rap lyrics, it should be excluded from the trial. I am going to give y'all an opportunity to file motions in limine specific to items of evidence in this case, and it may be that a particular item of evidence, which happens to be a rap lyric or a rap video, might not be admissible, but we'll hold that for another day after we know what it is we're talking about with specificity. Okay, there is, Mr. Eppinger has filed, or on his behalf has been filed, a motion in limine to bar the state from using particular language, including the words victim and crime. And I'm going to deny that motion. It'll be for the attorneys to, it'll be clear from the instructions that what is alleged still needs to be proven. And if not proven, acquittal is required. And it'll be up to the lawyers to do their lawyering to convince the jury one way or another with regard to what the evidence is. There's a motion in limine to prohibit the use of potentially prejudicial photographs, but I can't really make a ruling on that unless I know what photographs there are. I think this is talking about, well, it says crime scene photos or autopsy photos. Specifically,
Your Honor,
is there anything that I need to be looking at?
for clarification.
Sure.
We believe that the state will possibly attempt to introduce photographs involving Officer Rogers and Officer Johnson.
Okay.
More specifically, Officer Rogers in this case, the individual who was shot. And the police officer was allegedly shot in this matter by Mr. Eppinger. So we do believe that they may intend to introduce photographs of him as well as possible operating room videos and things of that nature, which we believe would be improper in this case.
All right. So has the state, this chart, it tells us what overt acts are still, I guess, at issue and what evidence is going to come in with regard to them. Do we have a chart of, and I know we have a witness list, do we have an evidence chart yet of the evidence that y'all think you're going to use for?
No.
No. Okay. Now that we have all this extra time, can we get one? Okay. Yeah, I think we can't answer that question until we know what the evidence is going to be. All right.
The state does intend to use photographs to show the injuries that Officer Rogers sustained when he shot 6 times. I think the case law and the supporting law allows us to do that because there's a charge related to that in relation to Eppinger with aggravated battery in order to show and present to the jury that there was either temporary or permanent part of Officer Rogers' body that was rendered useless due to the actions of the alleged actions of Mr. Eppinger at this time. I do believe the state is more than entitled to present those photographs. Now, I would agree with counsel, and I'm sure the court as it relates to duplicative photos that show the same thing over and over again, but the state has the right to present evidence in order to meet the elements of each crime charged with the indictment in order to be aggravated.
Which one is the aggravated battery? That's not actually charged as a specific crime, is it?
No, it's not.
It's like is that like a gang charge or?
Or related to, the attempted murder. So, Officer Rogers, I think we can
Okay.
prove that there was attempted murder, the 6 shots and the damages.
All right. I don't disagree. I doubt if Mr. Johnson disagrees that there's case law that permits the prosecution to use photographs to prove their case. What we need to sort out is some photograph so hideously, graphically offensive that it should be ruled out, and we can't decide that until we know what the photographs are. So once you put your chart together and you know here are the 5 or 10 or whatever photos we intend to use, then we can litigate specifically. Right now, I'm going to deny that motion. It's just too broad to grant. If there's a more specific one later, I'll reconsider, or I'll consider it later as it is specified. Okay, well, there, just get your,
Once we're able to get that list from the state.
okay. And again, y'all got the whole universe. And I think you have the more narrowed universe. But if we've all got it in some sort of a list or chart form specifically, then we can do the litigation that we need to do and then move on through the trial with an expeditious approach. All right, there is also Mr. Eppinger filed a motion limiting to limit testimony of state's witnesses. All righty, thank you. All right, the state has a supplemental notice of intent to introduce particular business records. Any issue with that? I think they've attached what the records, or the certificate of authenticities, the certifications. Anybody got an issue with that It was some Instagram records. Well, they're both Instagram records.
Your Honor, is that the one they sent?
Today or yesterday. Just, I don't know what, yesterday or, yes, today, yes. Yesterday, okay.
Your Honor, I haven't had the opportunity to review it. I'm sorry.
That's okay, it's only 3 pages, you can look at it now.
Your Honor, I've seen it, and I do not, as far as Defendant Eppinger, we do not have any issue with the certification itself.
Sure.
However, I do believe that there may be some authentication issues to be raised at trial.
Okay, let's raise them prior to trial.
Well, the only issue is, Your Honor, based on the certification, they give an allegation of a number that is associated with a particular Instagram handle, and in the evidence itself, I'm not seeing anything that directly correlates from that number that Instagram is given to the actual profile that it purveys to come from, as far as to make a connection that these records are from.
From the profile, or that the profile is tied to a person?
That the profile is tied to the particular data here. If you look, the name Big Chris, there's a number associated with that, and that is the number for which the data is given. So the question is, how do we know that that number actually corresponds from Facebook itself? There's no showing there that that number corresponds to that particular profile itself, which is listed by their number, the 646 number that they have on there.
I can show Mr. Johnson where the numbers correlate with each other within the record.
All right, if you'll do that, that'll be great. All right. Okay, we have a condensed state's witness list. Thank you.
And we just amended it yesterday, Your Honor, to add one individual, which was witness 104.
Okay. And we have, I believe, 2 people identified as gang experts. Is that right?
Yes, Your Honor.
All right. All right, any defense counsel have any issues with needing further information on how to contact any of those witnesses? All right. If y'all do, you don't have to wait until our next court date. You can just reach out to somebody on the state's team and let them know what you need, and they will endeavor to get that to you or somehow make sure y'all can get in touch with those people. All right. So I assume there are a lot of investigators. There are going to be fact witnesses. There are a couple of people identified as records custodians or crime lab personnel. Just want to make sure if there's anybody other than the people identified as gang experts and then the FBI CAS team person that is going to testify in an expert capacity. I guess if you've got crime lab or GBI, crime lab certainly would be an expert. GBI, I don't know whether those are going to be experts or not. Just if there's any, it would probably behoove the state to go ahead and identify this person to be testifying as an expert so that we don't get to court later and have any kind of assertions that somebody wasn't aware that we're going to be an expert. Okay? All right. Anything else with regard to the state's witness list that we might want to go ahead and talk through now? Okay. All right. All right. This, I guess, redacted indictment that the state has proposed to use in this case. It lists all of the defendants and it lists all of the counts. And then this is one way of doing it, but I've never seen it done that way before. Like when we're presenting this to a jury.
I was under the impression that's how we did it, but the last year had to be wrong.
I mean, I can go back and look, but I think there were a couple of counts that the court directed a verdict on, and we might have done it for those counts. But for counts that were not against any of the defendants then on trial, I feel like we didn't list them. I feel like we just listed the ones that the jury was going to have to render a verdict on. Because frankly, it's not that count 3 is removed from the jury's consideration. The jury wouldn't be considering count 3 because count 3 isn't against any of these defendants. Okay? So I don't think it should say that.
So do we leave it blank or do we renumber?
I mean, I think it's the language removed from consideration is just kind of potentially misleading.
You say not for your consideration?
It's just, it doesn't have anything to do with any of these defendants, so.
Not related to the defendants that,
Y'all think of something that seems a better, more accurate rendition. All right, I know one thing that I need to discuss with y'all is how detailed we want to get with our summary of the indictment when we're first saying, hey, jurors, here's a giant questionnaire. You might be on a 3-month trial. We need to know if you know anything about this case. I don't particularly want to read the indictment or even something close to the whole indictment 8 different times. Is there some summary we can come up with that is satisfactory to all of the parties that gives the potential jurors an idea of this is what they're talking about, if they're familiar with it? If they're not, then they won't know anyway, that is appropriate?
We believe that given the fact that these individuals are facing different charges and are not collectively charged together on every count, that it would be prudent to read each and every count to the jury so that they'll be able to identify and separate each of these individuals with regards to their criminal responsibility.
All right, let me ask you this. That's true with regard to everything other than count 1, which is the verbose count in the indictment. Can we narrow count 1 in some way, summarize count 1 in some way that says count 1 charges a conspiracy to violate the Direct Influence Corrupt Organizations Act by a pattern of racketeering activity, maybe even just some portion of that part 1, the conspiracy, without the entirety of the conspiracy is alleged, the entirety of the enterprise is alleged, and then the entirety of the still 53, is it still 53 overt acts that are alleged? State, is it still 53? Okay.
I had said the summary that includes my very short,
Okay.
my theory,
I,
very short one I said previously.
okay.
It just says this case involves members of the Young Slime Life YSL gang, including representatives of Williams, who are charged under the Racketeering Influence and Corrupt Organizations Act, also known as RiCO, for engaging in a criminal enterprise for racketeering and other related offenses. These charges range from drug possession and sales, murder, and other violent crimes which defendants have found not guilty.
Okay, well, that's a little slanted towards the state, but I'm sure we can use that as a starting point. It's certainly not going to say this case involves members of Young Slime Life, because that's something you'll need to prove, but good try. Okay. Y'all got a copy of that? Do we think we can take something, some part of that?
I haven't seen it, but it's also going to lead me to another issue about the jury questionnaire. We can take it now or later.
Okay. Are any of these 3 defendants charged with drug possession and sales? No, so we're not going to say that. All right, so the defense at least would want me to read with regard to, okay, here's what Mr. McMullen is charged with. here's what, Mr. Eppinger is charged with. Here's what Mr. Garlington is charged with.
Yes.
Okay, and then, that's fine. Those are short enough, and that's done normally. I guess so count one, which they're all charged with, is the one that I'm asking, is there some acceptable way to summarize that count instead of reading the entirety of the description and then all 53 acts, which take up 28 pages of the indictment? Well, no, that's not true.
Isn't the court going to have to read the entire document during jury charge?
Oh, the courts, well, during jury charges, but we're going to have already, done the case by then. I think at this point, when we're doing hey, here's what this case is about, that could be really short. And then typically I do read the indictment, or actually I usually have the state read the indictment because it's the state's indictment. It's not the court's indictment. But I'm happy to do, this is, generally a case alleging RICO, gang charges, murder, attempted murder, whatever the crimes are. And then they can read the indictment, but we don't need the entire indictment read just to figure out, here's enough about this case for you to say, yeah, I'm familiar with this, or no, I'm not familiar with this, or yeah, I followed this before, or no, I haven't, right?
My only question is that kind of confusing to the jury, because I'm hearing it for the first time at the end of the jury charges. Is that going to require them, well, is that all we're deciding when the first hearing, and then they're hearing 48 other counts later? Is that going to create a problem for them to know what they're doing?
I'm trying to remember, and I don't have my book with me, that's what I read once we've got our jury. Do we read the indictment again, Ben?
Yes.
We do, right?
I know there, you can, I know there is one of the indictments that's been very.
Let me-
You don't read it twice, and read it before, it's large pool.
I would think they're paying a whole lot more attention once they're actually on the jury. And if I'm only reading the full thing once before we start the evidence, I think it would be more appropriate to read it when we've got our jurors in the box and I'm saying, all right, y'all, here's what this case is actually about.
That would be fine with us.
Okay. I'm looking back at my typical outline to see what I do. Okay, so I think what I typically do is read the whole indictment because it's not usually a 50-page indictment during the jury selection process, and I don't actually read it again afterwards because y'all do your opening statements and you cover what you want to cover. But thoughts as to, my thought is if we're going to read it only once, we read it after we strike the jury. Does anybody have thoughts about that? All right, what do y'all think?
I would just suggest once.
Okay, and if it's once, do we think it's at the jury selection process or after we've chosen our jurors?
After we've chosen. I would agree with that.
Everybody on the same page?
I would assume that the issue that you're referring to is all of the overt acts.
Yeah, everything, yeah.
So I think that prior to the full, there would be no problem with reading the, I guess, the statutory definition of the RICO charge.
Okay.
And afterwards, you go to all
All right.
the 53 overt acts.
All right. Okay, so that's how we will handle it. And it'll be the state, somebody from the state that actually reads it since they brought it.
That's it.
And honestly, I do that in every case, even if it's a 2-page indictment. I don't think the court needs to be doing that. The court's here as the arbiter. Okay, so we'll read the entirety after we have the jury. And it will be by someone on the prosecution team. All right, so we still need to come up with how are we going to summarize it for purposes of the jury selection. So we have the state's proposal, and I can probably just print this one page out for you, Mr. Katz, if you want to take a look at it while we're talking about it, and maybe we can, if I can figure out. Well, I think I just printed the whole thing, but it's pretty short anyway. It's just going to be the top part of that page. So what I had, this was just me kind of putting something together, and we can certainly change it, but I was going to say, this case involves allegations of criminal gang activity and allegations of conspiring to engage in a criminal enterprise under the Racketeer Influenced and Corrupt Organizations Act, which is typically referred to as the RICO Act. The defendants are each accused of being associated with an alleged gang called YSL, or Young Slime Life, to have violated the RICO Act and to have committed certain other crimes. And you will also hear, I don't know, I don't think this is right, but you will also hear about a rapper named Jeffrey Young Thug Williams during this trial. Some of you may have heard something about this, you know, et cetera, et cetera. We can put more detail in, but that was kind of where I was starting from. Thoughts? Or I could say, and instead of to have committed certain other crimes, I can say, and, you know, Mr. McMillan's alleged to have committed murder, Mr. Garlington's alleged to have committed whatever he's alleged to have committed, and, you know, list them all out. What do y'all think?
Yeah, I like the way that you currently have it. I think it's.
I bet. Okay. And I could also say including murder and attempted murder, murder or attempted murder. Certain other crimes, just the way I have it. Okay. Now, the part about, I know we need to at some point say something about this is the one that's connected to Young Thug, because that's what's, if somebody is familiar, what's going to trigger for them, oh yeah, I watched every hour of that case, you know, or no, I've still never heard of him. So how do we, I mean, I don't know if the way I have it is right, and I can't remember. Let me look and see what Mr. Abadi had suggested.
Yana, did you have more commonly known as Young Thug?
No, I had a rapper named Jeffrey Young Thug Williams. I could say Jeffrey Williams, more, you know, no, who's, I don't know how to say it, music name, his rap name is Young Thug.
Right. I think they would more so recognize it if it was a
Okay.
separation.
Named Jeffrey Williams, who raps under the name Young Thug.
Correct.
Okay.
Would you mind emailing what you're reading, just so I can see it?
Sure.
Thank you.
I don't know. You know, how about I email it to Ms. Rosser, who has all of your email addresses, and she can email it to y'all. Let's see.
Judge, can I ask a question about this?
Mm-hmm.
The form you just gave me, I don't know if I put down over here, specifically questions when this form.
Oh, we're not, you don't need to worry about those questions. That was the state's proposed questions.
I know, but a couple of them, I
You
don't
like-
think we really have in here.
Okay, well, we can, and I know you're not the one who had this case before today. You're standing in for Mr. Mondelli. We can circle back on that. Okay. All right, does anybody have a better way or more to add to? You will also hear about a rapper named Jeffrey Williams who raps under the name Young Thug during this trial. Is that going to get us to, hey, this was Young Thug's case? Is there a better way to say that?
I mean, I think the allegation was that he's a leader,
Yeah. So, idea about how to say that? And, okay, so after he raps under the name Young Thug and who the state alleges? Okay.
When is that even relevant, Your Honor?
Well, it is to their RICO count.
I mean, but the RICO count is not dependent on the identity of the leader. So the fact that we're saying his name is something irrelevant, Your Honor, that would prove that there was some kind of criminal organization. The fact that it may or may not.
Yeah, I mean, they're not going to actually have to prove that Mr. Williams is in any way involved in YSL to potentially prove all of their charges against these defendants.
That's correct. So the question then is, what's the relevance?
Who? Well, the relevance of him being mentioned is that may be what triggers a potential juror to go, oh, yeah, I remember watching, you know, all of the testimony in the prior trial, and y'all presumably would all want to know that.
Well, I mean, we have questions that are asking with regards to have they heard about the case?
Right, but this is how we're letting them know, because when we actually get to those questions in the questionnaire, it's more like the events are alleged to have taken place between X date and Y date. We aren't saying right then, and they involve, you know, allegedly involve these people and potentially Jeffrey Williams and whomever else. So this is how we're kind of cueing them to, this is that case.
Well, then, in that particular situation, after discussion with Mr. Katz,
Mhm.
Your Honor, I do believe that we would have to add a question in there that's asking, have they formed an opinion based on their knowledge of the case, that would prevent them from being fair and impartial?
Okay, well, can we put that one on pause right now and come back to it? I'm trying to figure out the way to phrase how to alert them to, this is the Young Thug case.
Well, my question is, why do we have to alert them that this is the Young Thug case?
Because you may not want to know, but the other attorneys want to know if potential jurors followed that case.
Well, I understand that, but what I'm saying is the question that's being asked right now is based on how you want to read the indictment.
Right. Well, no, I'm sorry. This is not how I'm going to read the indictment. This is, hey, jurors, how are you? Here's what you're about to do. And here's some little bit of information, like the presumption of innocence, blah, blah, blah. Not going to read the whole indictment to you, but I'm going to tell you it's about this broadly.
Just for clarification, that's what I'm not to assume that the statement you're referring to will be made prior to me filling out this.
Yes. And that's how they'll know how to answer the question. Yeah, I've heard about this case. Yes, I followed it intensely, or no, I don't know what you're talking about. Anybody have any ideas?
I'm writing it down.
Okay.
Sorry.
And honestly, it doesn't have to be here if we want to, if it's more appropriate, when we say these events were alleged to have occurred between this date and that date, maybe we can put something about Mr. Williams in there. I don't know. I think for here, we at least need to say you'll also hear about a rapper named Jeffrey Williams who raps under the name Young Thug during this trial.
Maybe we did. And that's one.
Okay.
And I have also, comma, you may hear about a rapper named Jeffrey Williams, also known as.
Okay.
Rather than.
Instead of you will. Okay. Also, you may hear about a rapper named Jeffrey Williams. He raps under the name Young Thug during this trial. Okay. All right, so that's That then will be the language for my introduction. So for clarity's sake, once I do that, we're not going to read the full indictment before we ask them to fill out. And at this point, y'all would rather just say, am I correct in saying that the defense is fine with / prefers the more general language about a gang allegation, a RICO allegation, and certain other crimes versus the specific crimes that each client is charged with? Yes, for Mr. Dark.
I prefer the specific crimes for my client.
Okay.
So, just for clarification, are you referring to initial statements of the jury still?
Yeah. I mean, obviously, when we get the jury, I'm going to have the state read the full redacted indictment, and it will say, this is who's charged with what, and this is the specific charge.
Well, as far as the specific charges itself, prior to basically like this, I don't believe that all of the jurors have to know the specific charges as long as they are read to the actual jury itself.
Okay.
So in your first conversation with the jury, you do not have to read all of the charges.
Okay. All right. All right, so do you want me saying Mr. Garlington is also charged with attempted murder, possession, or participation, 2 counts of participation in street gang activity, murder, 2 more counts of possession? Well, it wouldn't be, I will already have said gang. So do you want me to go into those kind of specifics?
No, that's fine.
Okay.
Hey, Your Honor,
Yes.
with regards to the jurors that we bring in, I'm just as far, are we going to be doing this upstairs?
No, you must not have heard me say that at the beginning. We can't do it upstairs. So we're going to be doing it here, and it's going to be Monday, Tuesday, Wednesday, Thursday. We'll have 55 jurors in here. I will read preliminary instructions, which I'm happy to share with y'all. It's pretty much what I read before every jury selection. They will do their electronic questionnaires. Those, when they hit submit, it will immediately go by email to all of y'all, and I assume to me as well. And then anybody that wants to be heard on a hardship will hang around and we'll hear the hardship as well.
Okay, my question is, during that process, will you identify the defendants and jurors?
I mean, if you want me to.
Okay, I don't.
I can't remember when, let me see. I wasn't planning to, nor does it look like that. I don't know how Judge Glanville did it, but
Well, if you're not,
I wasn't planning to.
not planning to, then definitely will not want the charges read at that time.
Okay.
Just so I understand, each day that you do 55 jurors, they are each coming in that day and filling out the form the first time.
Yeah.
So you got to take that time each day.
Yes, either that or I do one videotape and play it each day, but I'm going to be sitting here anyway, so I kind of feel like I'll just read it. Okay. No, but once we have the real jury, then it'll be I'll have everybody introduce themselves and y'all say, here's me, here's my client, that kind of thing. Okay. All right. They will be reading names on their questionnaire to say, are you familiar with any of these people? Okay. All right. So then I think we're satisfied with that summary. So circling back to, do we in our questionnaire have the questions that the state has? We have some of them. I don't know if we have all of them. So let's look back. Mm-hmm. Okay. All right. Yeah, so we do have.
74, we're going to change the other, just to add also.
Yeah, attended court proceedings, yeah.
This is what you recall, but we don't, this court here did meet about just reading of the indictment, 4 and 5 are not in the question.
No, those are in it will say that the very first thing I'm going to say is, you're potentially going to be considering the case of the state versus these 3 defendants, and I'll read out their names. And then we're going to ask the statutory questions. And to me, the statutory question have you for any reason formed and expressed any opinion with regard to the guilt or innocence of, and I'm going to say any of the accused?
I understand that, but sometimes jurors don't understand or they don't know what exactly we're talking about. So if we didn't come to the pages, come up with number 75, 76, or 74,
Uh-huh.
well, you actually attended it, you still say that you don't have an opinion. And I still think it needs to be asked.
Okay, so just tell me what you're suggesting and where.
Have you formed an opinion about this case? Have you formed an opinion about the innocence or defense of the defendant, the innocence or guilt of the defendant in this case? And I take those two questions and put them, probably at 70, make that 78, 79.
Before 78 and 79 or after? Okay. So,
If I may add, I believe what Mr. Cass is attempting to accomplish is put it in the questionnaire to find out if what the individuals have found out about this case specifically has caused them to form an opinion or be impartial based on what they know specifically about the case from the sources that are.
right. Okay, so after question 77, add, have you formed an opinion about this case?
Isn't that what Bob here for? I mean, we're gonna, if they answer yes to that question, we're still gonna question and ask them the same thing, how, why.
Well, we've offered them more additional information. How did you learn about the case, or we know the case, did you attend the case? And therefore, after that, then answer that question again.
And it's also somewhat strange by the voir dire process because if we find out that they have some kind of opinion at this particular point, that may, their opinion that they express on the table may disqualify them, so we don't have to ask them some further questions. Or the attorneys may have different questions that may be asked on this subject that are not answered. So it may assist us in streamlining the voir dire process.
Okay, so here's the potential catch with that is this case against these three defendants who are going to be on trial in June and July is not the same case as the case that already occurred. And we might want to know, did they form an opinion about that case? And we might want to know, have they formed an opinion about this case? But that's not necessarily the same thing. And I don't want to in any way be implying that it is.
But I think we would be remiss as defense attorneys, not having seen a trial like this for over a year and a half years
Yeah.
publicity, if we don't deal with it at some point.
I mean, I don't disagree. I'm not saying I'm not going to ask it. I just want to ask it the right way. And have you formed an opinion about this case? I mean, I'm fine asking it, and then we can explore what their opinion really involves.
I think it would just be easier to say just to ask have they formed an opinion about both cases, have they formed an opinion about the prior case involving Mr. Williams, have they formed an opinion about this?
I mean, I'm not planning to volunteer, hey, there was an earlier version of trial with it involved. I mean, if they know it, great. If they don't know it, I'm not going to tell them that.
But then basically, given the fact that in your introductory statement, we're saying that this case may involve Mr. Williams, we're effectively telling them that up front.
Well, we're saying you may hear about him in this case. I mean, I think a lot of your follow-up individual questions are going to be, based upon what they say in this questionnaire, but the questionnaire goes to all 440 people, and I don't want to be suggesting something to people that they don't already know.
And I guess the only reason, Your Honor, because the court has a concern with regards to the length of these examinations.
Yeah.
The more that we can put in the questionnaire and get those answers.
Mhm.
will allow us to
Sure.
streamline that process.
Okay,
I mean, I think you have to live under a rock if you didn't know about this case.
probably, but I don't know. Some people just don't watch the news, and some people aren't on social media, so I don't know. We'll see. We'll find out.
So we're going to add those questions?
I mean, I'm trying to figure, yes, I right now have written down, have you formed an opinion about this case? And I guess the answers are either going to be yes or no. And then I can put on here, what is that opinion? Or y'all can ask them later, what is that opinion? Which would you rather?
I mean, I think that we can ask that because at some point, if a juror does indicate that they have an opinion, somebody out of either the defense or the state attorney inquires of that, so that information will come out one way or another.
Okay, so if yes, describe, or just yes or no?
Yes and no is fine, and it will be, I'm sure it'll be
All right.
picked up by somebody.
Okay. And then I think, have you formed an opinion about this case? Y'all will be able to launch into and figure out, does that include, have you formed an opinion about any other defendants in this case?
Or that's what I'm going to put up as a follow-up question in here, or we can do it
You want it as a question on the questionnaire?
As I stated, Your Honor, the more we can get on the questionnaire, will assist us in streamlining our follow-up questions. But if you feel that the questionnaire becomes too voluminous.
No, I mean, one more question is not going to make or break it. Do y'all want it? Yes, okay. Any of the defendants, it's written as related to this case, in this case, right?
And additionally, I didn't see it in there. I know that this is a question that I normally ask in a lot of my trials, but given the fact that the defendants will be present before they do the questionnaire, we can add in there. If there's anything about these defendants that may cause you any kind of unpleasant feelings or anything like that, I normally ask that at trials because I found that I've had some jurors who may have had a boyfriend that looked like him, they don't like him, or may have had a previous issue, if that could possibly be added.
All right, so if I'm doing that, am I identifying, here are the three defendants?
The defendants will be sitting here at the table, so they'll know these are the defendants.
Maybe they'll think you're the defendant.
I would hope so.
I mean, if I'm not saying it, I'm just saying, here are the parties, basically.
Okay, we can say parties.
Okay. Yes. Later, yeah. No, so, okay. The questionnaire is kind of supposed to be that yes/no voir dire part? Yeah.
Short questionnaire from the state, because in the previous cases that I've done, like the Hatter case, that was the questionnaire we did, to make their general knowledge about the case, and then we did normal voir dire as we normally would with everybody. Instead of doing a questionnaire that's 80 pages long, they have to fill out, you know, it takes voir dire so you get to know the jurors, so you're taking away everyone's ability to get to know the jurors because they just fill it all out on a sheet of paper.
I'm happy to not do the electronic questionnaire, but if we're going to do a questionnaire, it's going to be electronic. So I'm happy to not do a questionnaire.
I was curious if the questionnaire was taking the place of voir dire.
It is, I think, designed to take the place of the initial part of voir dire that is to the whole, whatever it's called, veneer, or, all of the yes/no questions. It's not designed to take the place of individual follow-up.
So the general voir dire questions.
Yeah. So with that knowledge, if there are some questions we need to add, then there are some questions we need to add. Sounds like one of them might be, here are the parties in the case. Here are the parties and the attorneys in the case. Anybody just really get under your skin? I won't say it that way, but, you know, right? Is that what y'all are proposing?
Yes, Your Honor.
Okay, I'll find some place to add that. All right. Anything else we need to add to the questionnaire? Okay. All right. How long does the state need to put together kind of their organized chart or list or whatever of what the evidence is generally going to be, which y'all were so great at towards the end of the last trial, so that the defense could have it and we could all be on the same page, and then they can say, oh, they're not even using that video, but they are using this one, and I'm going to challenge this one, because we're going to need to litigate all of that.
So my general response, and this may not be very good answer, the maximum amount of time you're willing to.
Oh, okay. That is not what the question was.
Would April 1st be reasonable? 30 days from today, March 7th. We all have other responsibilities.
March 3rd. Because then they've got to file their motions in limine. Okay, the state will have its beautifully organized and detailed list of its evidence by March 3rd, by noon, March 3rd, filed. You don't have to file it, just share it with everybody. Oh, which reminds me, I think I've said this before. In fact, I know I have, but anything that y'all need the court to see, like the list of evidence. Email it to Ms. Rosser, and/or email it to Ms. Rosser, Ms. Buggs, the court, and Ms. Persefield, as well as, you know, the opposing counsel. Do not e-serve it. Got that? Nobody e-serve us, please. That is quite a hassle. All right, email it. Okay, so that'll be by noon. You will email that out to everybody by noon on Monday, March 3rd. And then all of the defense attorneys who should have already looked at the entire smaller universe, galaxy, if you will, of evidence, once you get that list that is as close to final as possible, on the 3rd, I'm going to give y'all until the 17th to file, and these will be filed, all of your motions in limine that are specific, that say I'm challenging item number, whatever it is on their list, and here's why. And then we'll litigate it. Okay. And to the extent that all of y'all can get together behind the scenes before time to litigate in court, I'm going to actually set the court date to give y'all time after y'all's motions in limine have been filed for the state to take a look and go, oh yeah, that makes sense, or oh, we can do without that, or we can compromise on this, or I wonder what they mean, let me find out, and then sort it out behind the scenes cooperatively. Y'all do that, okay? It'll be much smoother for everybody. Sorry, so evidence-specific motions in limine by noon, filed by noon, March 17th, emailed to the court in addition. And then why don't we plan to have court on March 27th? We'll start at 9:30 and we'll just go as long as we need to. And we might need to go into March 28th as well. Can y'all look at your calendars and make sure those dates work for y'all? Okay, thank you.
March 27th, Thursday and Friday.
Mm-hmm. Those are good? Okay. Mr. Johnson, how about you? All right, I'll go ahead and block those out on your calendars. And then if y'all can resolve everything beforehand, we won't need to have those, but you probably won't be able to resolve everything, but you may be able to resolve some things. Okay, and then we'll go from there. Does that sound good? All right, anything else we need to think about right now?
Good, I just wanted to add something. I think we already denied a motion from the media to the videos. I just wanted to add another point to that.
Okay. I'm ready.
Good. Well, I understand, I appreciate the state's position that Baker did not involve a RICO in the gang case. It's still one of the main things they focus on, was it seems the state like using these rap lyrics and these videos, but to show that these kind of people that do lyrics, that do raps, have a propensity to commit crimes. And that's one thing the state, the Supreme Court focused on. And I would take a position that is another reason why we would ask it to reconsider its position in denying that.
All right, thank you. So I might need some clarification on, I think maybe it was Mr. Adkins at some point sent an email that said, these aren't overt acts anymore, but there's still going to be evidence presented of them. And is that going to be with regard to particular charged crimes in the indictment, or just with regard to RICO, or intrinsic to other crimes?
A little bit of both.
Okay.
To be honest with the court, in terms of some of the street gang charge counts and the count 1 RICO, like, evidence typically will go to both because they're part and parcel of the same. other than the different elements in this case. But that's why that last page of the chart, we want to identify, for clarity's sake, for all the court and defense counsel, which overt acts the state intends to introduce in the trial, even though they won't be on the redacted indictment.
All right. I guess if any of the defense attorneys have got a question or need clarification about what that means, y'all can just take that up with Mr. Adkins and he can provide clarity.
It really just means there's going to be objection or not, and that kind of overact. That's what it means.
Okay.
We want to be straightforward.
Okay. Okay. So that entire fourth page, then, those are not listed in the redacted indictment anymore, but y'all will be introducing evidence of them. And I assume the evidence will largely be what's in the fourth column?
Correct, Your Honor.
Okay.
And in fact, all of these on this chart, they almost are the evidence. Like
Okay.
either a video, a post, or a picture.
Okay.
Go
ahead.
There may be one or two that involve testimony.
Okay.
But like number 112, there's an actual, they're all social media posts or videos. So, yes, Your Honor.
All right. Okay, so then y'all, defense, need to take a hard look at page 4 of the chart, and if there's going to be any kind of a motion in limine you want to bring because you think, well, that is in no way even relevant anymore, or that is insanely prejudicial, then I need to have that specified so that we can litigate it.
Just so I'm just standing in here, just so I understand, those acts are prior acts, or are they just acts that are related to this case? I'm just trying to understand. Are we talking similar transactions?
So they're going to be, well, I think they're purported to be intrinsic, right?
What specifically?
Just this grouping of the overt acts.
So, yes, Your Honor. It was, for example, like some of these are photographs of what the state would report, gang identifiers or evidence of association with different members that are together. Any number of things that, these are all in the indictment, so it's clear like the date, time, and so it's kind of hard to answer how all 22 of these on page 4, they pertain to a plethora of different items in the case. In terms of street gang elements, RICO elements, there's a number of purposes. Evidence can be relevant for multiple purposes. So they're not, and then there's a couple on here as I emailed to the court and counsel in terms of the shootings of Ms. Frida Reed's home, the traffic stop near Trestle Tree after the fight at Magic City.
Right.
And there's one other one I'm missing off the top of my head. But other than those acts, which the state is articulating as intrinsic, this list is just to assist. Obviously, the chart we give on March 3rd will make it crystal clear what other evidence the state intends to introduce and through who. But this was just wanted to be upfront with the defense in the court if they didn't just remove from their mind considering what we redacted.
Okay, so the answer to your question is they are going, all of these 22 are, correct me if I'm wrong, going to fall somewhere between that January 2015 and April 2022. They're already listed in the original gigantic indictment, and they are still perceived by the state to be relevant to the charges in this case, if not the substantive counts other than RICO, at least RICO, but some of them may be to say, oh, here's how these two people were connected or something like that.
Correct.
All right.
But are they related to charges that have been, no process taken off?
No, so all of these are related to count 1 RICO. We just, for efficiency's sake, removed them for what the jury at the end is not going to be tasked with saying is overact 10, which is a facial tattoo YSL on Mr. Murphy. That may be an exhibit of the case, but it's not going to be an overact that the jury's going to go back there and deliberate. Is this an overact in purpose of conspiracy? It's just relevant for evidence. They all pertain to count 1 RICO, but some have multiple purposes. Street gang charges or other.
Do any of them fall under a similar transaction issue?
There's no similar transaction issue because of the count 1 RICO with these specific evidence. I mean, if you look at this list, other than these are, I guess I'm a little confused.
Well, like you mentioned, and like I said, I apologize, I'm not asking what it was. When you said it was one act where somebody shot somebody's house up.
Correct. So
is that particular victim listed as a victim in the count in this case?
So, no, to answer your question, well,
yes.
But in a different,
You see what I'm getting at? I'm just trying to understand.
Ms. Reed herself was not listed in the indictment, but that retaliatory shooting, there's an email that listed that is intrinsic to this case. I can talk more if you want.
It's-
It's kind of complicated, but-
Yeah, I think it's, what he's, I think asking is it intrinsic to a substantive charge against one of these defendants? Is that what you're asking?
And count one RICO.
Yeah, other than the count one RICO, like, is it any of the non-number one RICO charges that any of these defendants faces, is it intrinsic to one of those counts?
Well, the-
Is that what you're asking?
Yes, and would we still need to have a separate hearing on them?
Yes, if y'all want a hearing on them, yes, you're gonna have to allege something in a motion in limine that says should not be admissible evidence.
And that's why the state was identifying, so the defense counsel would know what other acts that are not counted we're going to use, so that if you have an objection.
And page 422, item 1.
So there's an email that Mr. Mandelli has that is from January 24th, 2025, so it has January 22nd, 26th, 2015 shooting in the street of rezone, the April 28th shooting at Club Crucial that preceded the 1428 Adele Drive, the 1903 Drew Drive later that night, which are over Acts 41 through 46, and then you have the October 1st, 2015, which was initially over Acts 56 through 59, which is where Mr. Arnold, Mr. Kendricks, Mr. Arnold gets in a fight in Magic City, and then they get to traffic stop over near Trestle Tree later on that night. It was over after the conspiracy to commit attempted murder, and then you have the May 10th, 2019, Javon Fleetwood attempted murder of Willie Howard Jr. So those four are what's in that January 24th email. And I know you didn't get it yourself, but defense counsel has Mr. Mullen has it. And then those four, and this was really just, if you look at the chart from number 4, a lot of these, other than those four I just mentioned, are just photographs or a video clip, something of that nature, that are outlined in the indictment.
All right, I have another question. Are there videos or rap lyrics that are intended to be admitted that are not listed on one of these 4 pages?
Not rap, music videos, something like that. No.
Okay,
There may be other videos, like from people's cell phones or something they post.
okay, but rap video, rap lyrics, everything that is one of those things is already in this 4-page chart.
Correct.
All right, y'all got that, defense attorneys? With regard to, your Baker type argument, you already have before you in this 4-page chart, any rap lyrics or rap videos that the state intends to introduce. So you can go ahead well before March 3rd and be looking at that and figuring out whether you want to file a motion limiting with regard to any of that.
That's the same on page 4 of the chart.
Yeah, but there may be, yes, it's the same chart. It's a 4-page chart, and the 4th page was used to be overt acts that are still going to be intended to be admitted, but not as overt acts anymore. The first 3 pages are overt acts, right? Still,
Correct.
okay.
And by the state, from reviewing it, there's only 3 that could be, that I view as classified in the Baker type analysis,
Okay,
which was.
that's 3 you mentioned before. Okay. But there are other, okay. Okay, so anything else that says like video, that's not like a rap video, that just is like some Instagram thing or something?
Correct.
Okay. Okay, thank you.
Yes, Your Honor.
All right, I appreciate everybody's time. Is there anything else anybody thinks we should be discussing right now?
Your Honor, I just wanted to put on the record, just ask that, of course, our clients remain here and not be sent anywhere else, so that we'll have time to confirm. My client specifically was concerned about being sent back to DOC.
Okay, I don't know the answer. Ms. Rosser.
They will only send them back if we request them to be sent back.
Does everybody want their clients to stay? Okay, then we will not request that they be sent back, and so they will stay.
Judge, that does not include Ms. Eppinger. I have no
Oh, yeah,
control over that.
Mr. Eppinger might, I don't know what Mr. Eppinger's situation is. We might need to talk separately about that. But Mr. Garlington and Mr. McMullen, we'll have to find out whether that's possible. Okay.
Your Honor, is there
Yes.
time that we can come by to pick up the evidence from?
Oh, I had another question. Yes, I don't know what that time would be, but you can coordinate that with Ms. Rosser. And as you know, we had 3 different court reporters on that trial, and one of them is no longer employed by Fulton. One of them is not full-time. Well, they may be full-time, but they're a floater. And my court reporter will be back soon, but is not in the office currently. So it might, I'm not sure who has it. One of the 3 of them has it. Probably my court reporter. I just don't know. But yes, we can figure that out. let me ask y'all. I have already assumed that you would want the testimony of like Officer Rogers, and I can't remember the other officer's name, but the testimony from the first trial related to that incident. So I already asked the court reporters, please be getting that transcribed. Is there any other witnesses' testimony, and I'm not saying we can guarantee this, but that y'all know you want?
I think that it would be appropriate if we were able to obtain any witness that statements in the call that testified the first time. If they testified in the first trial.
All right, we're talking about 132 witnesses. So that may or may not be possible. And it may be that you don't want Ms. Latner's testimony, the 911 person. So take a look at their witness list and prioritize it, okay? And then give the court the, I don't care if you list it all the way 1 through 135, but give me the priority in which you would like that so I can tell the court reporters, please focus on this witness, then this witness, in case they don't get through it all, okay? All right. I mean, honestly, they're still working on that Officer Rogers testimony, the people around that right now, so they haven't even moved on past that. Can you have it to me in the next 10 days? Okay.
Yeah, could we just, we don't need nearly as many, we just have 4 people.
Yeah, just, if you want to go ahead and send me that list, go ahead and do it.
We'll send it to them.
Okay. All right, anything else? Okay, thanks, everybody.